Hello, everyone, and welcome. My name is John Harkins. I'm the Events Associate for the French American Chamber of Commerce New York chapter, and we're happy to welcome you to our webinar today, J1 Visa and Immigration Updates, Information on the Most Recent Presidential Proclamation. Just a very quick word about our organization before I hand it off to Mary Beth Lambert, our Associate Director of International Career Development Programs. The French American Chamber of Commerce mission is to provide the opportunities, experiences, and understanding that empower successful business relationships between and for members. The FACC-New York counts a mosaic of 1,000 members representing sectors from tech to food, finance, and other professional services. These members have complimentary access to digital events featuring top industry experts and leaders, as well as personalized member-to-member introductions, access to the FACC member directory, and of course, we'll be able to connect with other member attendees of this webinar. This webinar will last about 45 minutes or so with time for questions and answers at the end. And of course, the webinar will be recorded, so don't worry about missing a thing. I'd now like to hand it off to Mary Beth, who will introduce our topic and speaker. Mary Beth?
Thank you, John. Good morning, everybody. Like John said, my name is Mary Beth Lambert, and I'm the Associate Director of the FACC's International Career Development Programs, which includes managing the J1 Visitor Exchange Program. This program brings young talent from abroad to train in U.S. companies with the ultimate goal of cultural exchange and mutual understanding. And the FACC has been a designated sponsor by the U.S. Department of State for this international exchange program for over 45 years. As everyone knows, on June 22nd, 2020, President Trump issued an addendum to Presidential Proclamation 10014, effectively suspending entry of various non-resident alien visa categories. We will be discussing this addendum today with Karin Lestelle of Fragomen, Bernsen Loewy, LP. I am so happy to have Karin with us today to help us understand what it means for current visa holders, while also exploring how this plays into the greater context of current travel bans and what future restrictions may be on the horizon. Karin provides immigration policy guidance, strategic planning, and advice and program support, primarily to international corporations, including numerous French companies. Karin represents a broad array of companies in the financial, luxury, consumer packaged goods, insurance, information technology, and scientific industries, among others. Karin is active in the French business community, serves on the board of directors of the French American Chamber of Commerce in New York, and is a frequent speaker on immigration law topics. Welcome, Karin, and thank you for being with us today.
Thank you so much, Mary Beth, for the introduction. And thank you for having me today. So I think we can go to the next slide. The one after that, we don't need my picture. Okay, so the agenda today is I'm here to talk to you about the scope of the Presidential Proclamation and exemptions and waivers. And before we delve into that, I thought I would start with a little bit of an introduction. As Mary Beth said, this is actually a sequence to the initial Presidential Proclamation back in April. Many of you may remember on April 23rd, President Trump tweeted that he was going to suspend all immigration to the US. Needless to say, that caused panic and consternation in the community, and a proclamation was issued a few days later, which in fact had very limited scope and applied to a very limited number of green card applications, which I'll touch on a little later in the presentation today. But an important part of this proclamation was a directive to the Labor Department and Department of Homeland Security to study the impact of foreign nationals on US workers. And that's what led to the proclamation from a few days ago. And the important thing is, if you look at the title of the proclamation, it's titled Proclamation Suspending Entry of Aliens Who Present a Risk to the US Labor Market Following the Coronavirus Outbreak. So that's important to keep that title in mind because it really sets the tone for what this is designed to do. The other thing at the outset that I just wanted to point out that it's interesting from a legal point of view is, where does the presidential authority come from for this? It comes from a statute, Section 212F of the Immigration Nationality Act, which gives the president broad authority to suspend the entry. And entry is really the key and operative word in this context of foreign nationals to the US when deemed in the national interest. And that's the basis for this whole proclamation. It all relates to entry. It is far more difficult to impose restrictions on foreign nationals who are already here in the US. So that's a little bit of context. And with that, I think we can dive into, go to the next slide and the one after that, and talk about who is subject to the non-immigrant visa restrictions. So I'll start with the lower part of the slide. It's not all visa categories. So the visa categories that are affected are listed here. H-1Bs, obviously a key provision. Probably the majority of foreign nationals on temporary work visas are H-1Bs. H-2Bs, temporary workers. Importantly, L-1As as well as L-1B intra-transferees. And that's a little bit different than what we had expected. While this was all in preparation, there were many rumors going around and we were hearing what the government agencies were considering. The expectation was that L1As and executives and managers, because they're typically in very senior roles, would be exempted, and unfortunately they were not. Then, of course, J1s, most J1 categories, including interns and trainees, obviously affects the J1 sponsored programs like the one that the French Chamber has, and also teachers, camp counselors, au pairs. Again, we had heard initially au pairs were supposed to be exempt, and they ended up being put into it, and summer work travel. And then the final one is if a principal applicant is subject, then their family members are as well. So those are the ones who are included. Now let's turn to the actual proclamation and who does it affect, and the 3 bullet points above. And it's very important to focus on the word "and," because that is critical and really limits, the good news is that really limits the scope of the proclamation. It applies to foreign nationals who are outside the US on June 24th. So you have to have been outside the US, not hold a US visa, and not hold advance parole or another US travel document. I won't dwell on that one too much. It has limited scope. Advance parole applies mostly to people who are already in the green card process in the US. So, the operative word is you must have been outside and you can't have had a visa. So a classic case would be if a company is thinking about transferring and was about to process an L1 visa for a new employee, for somebody, for example, who's in France. I'll focus on France since it's a French Chamber event, who's never been to the US, planning their transfer for September. Well, unfortunately, that's not going to happen. That person would be subject to the proclamation. Next slide, please. So who is exempt? The good news, as I said, I know this created, again, a lot of consternation and concern among all foreign nationals. Needless to say, we had many, many requests for calls and were deluged by emails by people wondering how it affected them. In fact, there are a number of exemptions. So the most important one, which I think applies to probably most of the people who are on this call, because I'm assuming most of you are physically here in the US today and were here yesterday, is that if you are in the US today, it does not apply to you. So that is going to be critical in the future. I want to, at this point, caution you that just a couple of points, that even if you're exempt from the proclamation, doesn't necessarily mean that you can or should be traveling internationally. And why do I say that? Is you have to remember the focus of this presentation is on the Presidential Proclamation. However, there are other very important things that are restricting the entry of foreign nationals right now to the United States. First of all, we've been dealing since mid-March with the fact that the US consulates have been closed. They give every month, they were giving in March, they canceled appointments, then they gave them for April, canceled April, et cetera. It's a rolling ball. And right now the consulates have yet to reopen. We're getting appointments in July. We don't know whether they'll happen. So we have to deal with consulate closures. And the other thing is we have to deal with travel bans. In a nutshell, we have many travel bans, COVID related, where if you've been in any of the Schengen countries, UK, Ireland, China, most recently Brazil was added to the list, Iran is also on the list, in the last 14 days, you're banned from coming to the United States. So my point on this is that even if you're exempt from the proclamation, you still may not be able to come to the United States. That's my essential point, and my general recommendation to my clients and to you as well is exercise extreme caution before deciding to make international trip, and certainly, check with counsel before you do so, because as I said, there are a number of things to be considered. So with those words of caution, back to who is exempt. So the second exemption is even if you were in the US, outside the US, sorry, on June 24th, if you have a valid visa or other travel document, you are not subject. So that's an important exemption, and it doesn't have to be. Again, we're doing a strict reading of the statute. There may be, a lot of this remains to be seen, and we may see different interpretations by the various administrations. But even, for example, if you were planning on applying for a J1 visa or an L1 visa, and you didn't have one and you were outside the US, but you happen to have a valid visitor's visa that had been issued to you previously, our reading of this is that you're not subject because you did have a valid visa on June 24th. Again, a bit of a gray area, but we think we're on fairly strong footing on that score. Also exempt are permanent residents or green card holders. Excuse me. Sorry about that. One of the perils of working from home. It should stop shortly. Okay. Spouses and children of U.S. citizens, and in the J1 category, J1 research scholars, professors, all those categories. Sorry. Hopefully it will stop soon. And the last exemption, which may be very important for some, is if you're coming to provide services essential to the U.S. food supply chain. We don't know, so if you're working for a food company, that may be a very significant exemption. We're waiting to hear. We have no guidance on how that's going to be interpreted. And where it may be some time before we get guidance. But those are all the categories that are exempt. Okay, I think we can go to the next slide. So there are a lot of, in this area, there's some things we know. There are a lot of gray areas. So a couple of the open questions, one of the questions that came up first was, well, what about Canadian nationals? Because you've seen all the reference to visa. And in fact, Canadian nationals, even though they need work authorization to come to the United States, they actually don't need to get a visa at the US consulate abroad. It seems to be, very fresh off the press, we were just given guidance that the good news is they should not be impacted by this. So that's good news. Again, impact if you're, in a category other than those, how does it impact you? You can have a situation where you might be here on a student visa and then planning to apply for an H1, and all those are a bit of open questions. Also, and a lot, my point on this is, a general slide is, a lot remains to be seen. This is brand new as of 3 days ago. So we're going to have to see how consulates interpret this, how, the CBP at the border interprets it. So, but another, important point is you could very well have a situation where Your principal applicant, already got his L1 visa, so he's not subject, but his family did not have it yet. So what happens to them? Again, gray area. Another gray area. What about, could you, if you were a family dependent and you couldn't come in because you were subject to that restriction, could you maybe come in as a B2? Personally, I think that's very risky, but those are the things we'll be looking at. So again, I think the main point of this slide is we're going to be finding out and getting more guidance within the next few weeks. We should have a much better idea as to some of these fine-tuned questions. I think we can go to the next slide. So waivers, and the one after that, sorry, John, thank you. So there is the possibility of waivers. If, the basic concept, if it's deemed to be in the national interest. So I will start by the two lower bullet points because they're pretty specific. Clinical care or research related to diagnosis, treatment, and prevention of COVID-19, and critical to defense, law enforcement, diplomacy, or national security. The point I want to make about this is pretty narrowly written and focused. So I don't think we're going to be seeing broad discretion being applied. The category that we're probably the most likely to try using is foreign nationals who are necessary to facilitate the immediate and continued economic recovery of the US. So undoubtedly, with our clients, when important transfers and are going to be contemplated, this is something we're going to be looking at. Again, it totally remains to be seen how strictly or broadly it will be interpreted. But if you look at the wording, just the use of the word necessary, it implies a very direct connection. So our expectation is that these waivers will not be readily obtained, that it's going to be very much the exception rather than the rule. And the other point I want to make on the waivers is if you have somebody who is you really need critically, very senior person, critical role in the US, etc., this is not the only waiver you need to get. You have a bunch of hurdles to overcome. Going back to what I said before, I mentioned the consulates are closed. There's a procedure where you can request an emergency appointment at a US consulate, again in the national interest. So you would have to one, get a emergency consular appointment. Number two, you need to get a waiver of the Presidential Proclamation. And number three, if you're subject to one of the travel bans, and you would need to get a waiver of the travel ban. So obviously getting waivers is not going to be an easy feat in any event. Okay. I think we can turn to the next slide and the one after that. So effective date and duration, it starts on June 24th. It lasts until December 31st. And it also extends the immigrant visa restrictions that took effect on June 22nd. And that's what I referenced very early on in the presentation. The first presidential proclamation back in April affected green card applications that were being processed where the final interview was going to be at the US consulate abroad, a procedure we call visa processing. And that ban was put into effect for 60 days, was supposed to expire on June 22nd, and this ban extends it through the end of this year. The other salient point is, the Labor Department and DHS and the State Department can recommend modifications to the ban. They can extend it. They can expand it to other visa categories, which goes back to, at the risk of sounding like a broken record, my recommendation to exercise extreme caution in traveling internationally if you're already in the United States. So that, before we conclude, I don't have a slide on this, but I just did want to touch briefly by way of conclusion. The good news is, again, the scope is limited. as I think I've hopefully clearly explained. The bad news is we still have to factor this in with all the other travel ban and the consulate closures. And the other thing is we have not seen the end of this on the part of the government. We fully expect forthcoming regulatory and administrative actions. Again, this piece of it, because it relates to entry and relies on that section 212F of the Act, was fairly easy to accomplish. But the government is very much planning, and most likely pretty soon, especially with the presidential election looming, on publishing more regulations which are likely to severely restrict visa categories. That we expect that they're going to seek exemptions to the normal rulemaking procedures to make things basically go faster. We may see things like imposing, some of the rumors we're hearing are imposing a $20,000 filing fee on H-1B visa petitions, severely restricting the definition of what's a professional occupation, imposing wage obligations, joint employer obligations. So we're more to come in this area, and unfortunately not likely to be positive for business immigration. So I think you can go to the next slide. So thank you very much, and I think we can open it up to questions.
Absolutely. And while we just answer some of the first questions, I'd like to remind the audience that if you have any more, feel free to send them into the question chat function. Karin, the first question that I think is on everyone's mind, is there any aspect of this proclamation that is open to interpretation enough to be challenged within a court of law?
Yes, that's an excellent question. There will undoubtedly be challenges, although honestly, we didn't see any challenges to the previous proclamation in April. And again, the section that's, I think, what will make challenges to this extremely difficult is the fact that the president has very broad authority to ban, again, the entry of foreign nationals under that section of the law. So I suspect that challenges would be, I'm sure people will challenge it, but whether it would work is I think very questionable. I mean, among other things, when the Trump, the Muslim ban was ultimately held up by the Supreme Court under the specific statute. So I hope that answers the question.
Well, just as a follow-up question, if there are challenges, does the proclamation stay in effect in the meantime?
That would depend on what the courts decided, if they stated. I mean, they did in the case, again, going back to the Muslim proclamation, there were stays issued. Okay. So possible.
Next question, different topic. Given the economic downturn, what is the likelihood for a labor certification application to return negative, i.e. to be denied to support a petition for permanent residency?
Okay, well, that's unrelated question to this, but I certainly deal with this all the time. Obviously, the challenge in the area of the permanent labor certification, it's a test of the job market. So an application can only be successful if a company can demonstrate that it was unable to find a single minimally qualified U.S. worker. We do expect, when the economy was very strong, we were seeing fewer audits because unemployment was extremely low. As unemployment goes higher, there will undoubtedly be more audits from the Labor Department asking to see resumes and the company to document its efforts. There are two things that have an immediate impact on likelihood of success of a perm application. First of all, if you've had layoffs, it precludes a company from filing within the next 6 months, except in very limited circumstances, unless they notify the workers who are laid off. So layoffs, hiring freezes will basically stop the company's ability to proceed. And we have another very practical problem these days due to COVID, which is, not to go into too much detail, but the perm process requires a physical posting and notice to all employees, and that's been a challenge because many companies are closed. So.
Sure. Just going back to the proclamation, do you have any guidance or any idea of when we will get guidance on how to interpret the J1 exempted category food supply chain?
Category? I'm sorry?
The J1 exempted category food supply chain?
No, I have a great interest in it personally, but yesterday what I heard from one of our partners who's very closely connected to the government is that we're not likely to hear immediately. So what does that mean? I think we're not going to hear for at least several weeks, but that's going to be an important exception.
And just to quickly follow up on that, if we were to get guidance and if we were to hear in the next couple of weeks, where would the average person find that information?
Well, at Fragomen, we put out client alerts, and we have a lot of information on our webpage. I know there are many other sources, but at least as far as we're concerned, we regularly put out client alerts, and our webpage has pretty up-to-date information. So I certainly would suggest that.
And without getting too detailed into the very specific visa categories, just this question: how will this affect the renewals, extensions of visas like H-1B?
That's a very good question. I mean, again, the good news, it has zero impact on extensions filed through the U.S. Immigration Service here in the United States. So that's very good news. Same thing for L renewals. The issue we have is, I'm sure everybody who's been dealing with this knows that there's a high rate of request for evidence from the U.S. Immigration Service. So dealing with that, I think the interesting question is if you have an L1 and we're under a blanket, we're planning, normally many companies send their foreign nationals to the U.S. consulates to renew, and whether that could be done. I think it can, but I would reserve a little bit to see how things develop before I give that definitive advice to clients.
Okay. And how do you anticipate this impacting the business of immigration lawyers beyond the obvious immediate uptick in clients reaching out? Do you anticipate to handle less immigration petitions, or that the demand will just shift to other categories?
I think there's going to be a lot of demand shifting to other categories. Again, the good news is that this is really quite limited, right? In terms of, I think mostly, what it's going to affect is companies who are planning new L1 intracompany transfers, because for the next 6 months, that could be impacted. And I think there are going to be some companies, I've already had some companies say, okay, well, we'll defer that person's transfer to the United States until the first quarter of next year. But if you look at other categories like the H1, we all know we have the H1 cap. So the new H1s were done, we're done with them. So it's not like we were filing any new H1 applications until next year.
Since this proclamation, as you mentioned, restricts entry only, does that mean that embassies can technically still issue the visas?
Yes.
Okay, very simple. And you had mentioned that you anticipate that there are rumors of new proclamations on the horizon. Do you anticipate a new proclamation before getting any updates on this current one?
No, what we expect are actually, we don't expect new proclamations, we expect new rulemaking is what I think we're going to be seeing. Where those other changes could not be made unilaterally by the president, changing regulations. This could, again, because it goes back to that statute.
Okay, and just one more question on the H-1B activity. How was this activity? How about H-1B activities like renewals or moving companies? How will this impact
Again, the good news is it should not. If you do an H1 transfer or an H1 renewal through USCIS, this has zero impact on you. The question where it comes in is if you decide to travel back to your home country and you're going to be applying for the visa abroad. Again, technically, if you were here on June 24th, regardless of whether you had a valid H1 visa already, you're not subject, but that doesn't mean that you should be going, because you're likely to be, one, the consulates are closed, and two, you may be subject to a travel ban.
Well, thank you for that quick fire round of Q&A. That's all the questions we've actually gotten at the moment. But I want to, tell the audience that these questions can be, directed to us and to Karin, and we can do our best. And then, but Karin, I would like to just thank you so much for taking the time to be with us. Thank you so much for giving this update and providing some clarity on a pretty interesting and confusing topic at times. So thank you so much for doing that. To the attendees, thank you so much for tuning in. And I'd just like to point out that we have another webinar on the 30th on increasing cash flow through R&D tax credit, a little known tax credit that companies can take advantage of at any point. Karin, once again, thank you so much for taking the time. I know we will speak soon, of course. I know we'll speak soon. And once again, to everyone involved, thank you so much for tuning in.
Okay.
Take care, everyone.
Thank you, and apologies for the dog.
No problem.
Okay. Thanks,
Take
everybody.
care.
Bye-bye.